Insurance companies in Colorado are routinely violating the law when it comes to their attempts to negotiate and settle personal injury claims before they are allowed to. And so this video will go through and explain what the actual law is that controls how soon an insurance company can try and settle a personal injury claim, and then also show a real-life example from one of our clients where this happened very recently when an insurance company in Colorado tried to settle the claim before they were legally allowed to. So first what we'll do is explain what is the law in Colorado that controls how soon an insurance company can try to negotiate and settle a personal injury claim, and how soon they can even get a statement from the injured victim after an accident occurs. And so the law that controls in Colorado is Colorado Revised Statute 1321-301. And that relates to settlements, releases, and statements of injured persons. And here's the law. It says that if a person is injured as a result of an occurrence which might give rise to liability, in other words, that means did someone get hurt in a car crash or other personal injury where somebody else may be at fault, and that person is a patient under the care of a practitioner of the healing arts or is hospitalized. In other words, was the person hurt? Did they have to go see a doctor or some medical provider, and or were they hospitalized? No person or agent of any person whose interest is adverse to the injured person shall. Now that's key language. That says that the person who is at fault for causing the injury or an agent of that person, which means their insurance company, they cannot, A, within 30 days after the date of the occurrence causing the injury, negotiate or attempt to negotiate a settlement with the injured patient. So within 30 days after they hurt someone, after their insured hurt someone, they cannot try to negotiate or try and even settle the claim with the injured victim. B, within 30 days after the date of occurrence causing the injury, they cannot obtain or attempt to obtain a general release of liability from the injured patient. What that means is they can't try and get the injured victim to sign a release waiving any claims and any liability against their insured. And finally, C, within 15 days after the date of the occurrence causing the injury, they cannot obtain or attempt to obtain any statement, either written, oral, recorded, or otherwise, from the injured patient for use in negotiating a settlement or obtaining a release except as provided by the Colorado Rules of Civil Procedure. So that's the law that controls what insurance companies can do after one of their insureds causes an injury to somebody else. And the law goes on to say that any statements or settlements that violate that statute are void, and they're not enforceable against the person that they obtain that statement or settlement from. But that's really the only remedy that an injured victim has if an insurance company violates this law. There's really no teeth behind the law other than if they do this and if they get caught, the settlement or the statement that they got is void and they can't use it against the injured victim. So, in our opinion, that's one of the reasons why insurance companies are trying to get around this and break the law, is because there's really no teeth behind the statute that protects injured victims. The only thing that we can do is advise people in Colorado of their rights, and so they are informed and they know going into it that if an insurance company tries to do this, they can call them out on it and say, You're not allowed to do this. You're not allowed to take a statement from me, and you're not allowed to try and negotiate a settlement of this claim within 30 days after it occurs. So I promised that I would show you a real life example of this that happened to one of our clients. And I've been hearing for years that insurance companies have been doing this, that they are immediately contacting the injured victim and they are trying to get them to settle the case, and they are offering them some low arbitrary settlement amount that really has no relation to the actual injuries that the person suffered. Because within a few days or a few weeks or even within a month after the accident occurs, there's really no way to tell how much damage was caused to the injured victim because of the accident. So why would an insurance company try to do this? Well, in our opinion, it's because if they get to the injured victim quickly, if they get to them before they've had a chance to consult with a personal injury attorney, they're going into it without having the information that an experienced lawyer would give them, and they're not as sophisticated, understandably, in negotiating personal injury settlements. And so the insurance company is capitalizing, literally capitalizing on that. And so they are taking advantage of people who've been hurt by trying to get them to settle early because, number one, they won't have a lawyer and they won't know what things they need to do and how much treatment they will need and other factors that go into their claim. And number two, if they can resolve the case early for some low arbitrary amount, it gets it off their books. And they know that if the injured person actually goes and gets a lot of medical treatment because they're really hurt, that will increase the value of their claim. So here's a real world example that happened right here in Colorado by State Farm, was the insurance company for the at-fault driver. And here's a letter that State Farm sent our client within 13 or 14 days after the accident happened. But you can see right here that the letter is from State Farm. The date of the letter is highlighted. It's February 4th, 2025. And if you look where it says date of loss is January 21st, 2025. So that is 14 or so days after the incident, after the accident happened. And so State Farm's already sent this letter to the injured victim within 2 weeks of when they were hurt. And you can see here, it starts off, "We hope you are doing well and are recovering from your injuries from this auto accident." So right there, they are admitting that the injured person was hurt, which is exactly what the statute says, is that if they know that the person was hurt and they sought treatment from a doctor, they can't do this. It goes on to say, "We previously extended a settlement offer to you in the amount of $2,500 for the settlement of your injury claim." And then they go on to say that there's a promise of payment for any reasonable and necessary medical expenses within 180 days following the date of the accident. And so right there, State Farm is violating the law that we just talked about. It was within 30 days of the injury-causing incident. And not only did they take a statement from the injured victim, because they said that when they talked to him, but then they offered some arbitrary low settlement amount to the person who was hurt. And so it's clear that the insurance companies are doing this. And the purpose of this video is to hopefully educate people in Colorado. So if you are in a crash and if an insurance company tries to take advantage of you, like State Farm did to our client, you'll know your rights and you'll know what to say to the insurance company to let them know that they are violating the law, they're breaking the law, and they're not allowed to do this. If you have any questions, go ahead and put them in the comments, or feel free to call us at 303-919-7777, or contact us through our website, kanetrial.com.